All right, let's jump right into this explainer about a truly bizarre legal judgment from 1932 that fundamentally revolutionized consumer protection. We're looking at a legendary case from the UK House of Lords, widely known as Donoghue v. Stevenson. It's a crazy story that starts with a simple ginger beer and somehow ends up shifting the very foundations of the common law.
So I want you to think about this for a second regarding your own everyday purchases. If a product you buy poisons you, can you sue the maker? I mean, today it seems like an obvious yes, right? Well, before 1932, the answer was actually shockingly complicated. Under the super strict rules of the time, the legal system often just left the injured consumer completely out in the cold. To understand why, we really have to look at the exact events that triggered this massive legal battle.
Section 1. The Snail in the Bottle. Let's head back to August 26, 1928. Our story starts on a completely ordinary day in a cafe in Paisley, Scotland. What began as just a simple social outing for two friends quickly turned into an absolute nightmare. First, a friend orders a ginger beer and ice cream for a woman named Mrs. Donoghue. The shopkeeper then pops open the bottle and pours part of the ginger beer over the ice cream. Mrs. Donoghue eats some of it. Then, step 3, her friend lifts the bottle to pour the rest of the ginger beer into the tumbler. And that brings us to step 4. The decomposed remains of a snail float right out of the bottle. Now, the absolutely crucial detail here from the source material is that the bottle was made of dark, opaque glass. Literally nobody, not the shopkeeper, not the friend, not Mrs. Donoghue, could see the danger lurking inside until it was way too late.
Obviously, after consuming that contaminated drink, Mrs. Donoghue got extremely sick, suffering from severe shock and gastroenteritis. But what's truly fascinating about this whole situation is who she actually targeted in the lawsuit. She didn't sue the cafe owner who sold the drink. Instead, she went right to the top and launched her lawsuit directly against Stevenson, the manufacturer who bottled the ginger beer. And let me tell you, in the legal landscape of the late 1920s, that was a massive, almost impossible leap to make.
Section 2, the contract law trap. We're talking about a very rigid legal system.
Here is the giant legal wall Mrs. Donoghue had to climb. Just consider this absolutely bizarre trap of the law at the time. Her friend was the one who actually purchased the drink from the cafe, meaning the friend had a legal contract with the seller. But the friend wasn't the one who got hurt. Mrs. Donoghue, on the other hand, drank it and suffered the physical injury, but because she didn't actually hand over the money, she had zero legal contract with anyone. The rigid law back then basically said you could only sue if you had a contract. So the person who bought it wasn't hurt, and the person who was hurt didn't buy it. Total deadlock. This perfectly illustrates the massive historical tug-of-war judges were dealing with. On one hand, you had the strict old law, seen in cases like Winterbottom v. Wright from 1842, which ruled that an injured mail coach driver couldn't sue the maker of a defective carriage purely because he didn't personally hold the contract for its repair. The rule was brutally simple: no contract, no case, period. But then you had these rare, messy exceptions, like George v. Skivington from 1869, where a chemist was actually held liable for a noxious hair wash that injured a purchaser's wife. The legal system was completely divided on whether a manufacturer had any duty of care to someone they didn't have a direct contract with. This roadblock was formally known as privity of contract. It's basically the legal rule stating you can only sue for a defective product if you directly entered into a contract with the seller. Because of this extremely strict rule, the lower courts were just totally baffled by Mrs. Donoghue's claim. She simply had no privity of contract with the manufacturer. Because of this, the case escalated all the way up to the House of Lords, which was the highest court of appeal in the UK. Section 3, the fear of floodgates. And this sparked a massive debate in the House of Lords. Up in the highest court, 5 eminent judges waged an intense ideological war over whether a manufacturer owes a duty to the ultimate consumer completely independent of any contract. On one side, you had dissenting judges, led by Lord Buckmaster, and they were absolutely terrified of opening the floodgates to endless lawsuits. He asked a really pointed question: if one step, why not 50? He basically argued that if they allowed her to sue a manufacturer for a bad bottle of ginger beer, well, there would be nothing stopping anyone from suing the builder of a house if a ceiling negligently fell on them years later. He just saw no logical stopping point. These strict traditionalists argued that, yes, sure, there were exceptions to the contract rule, but they only applied to inherently dangerous goods. Things like loaded guns, explosives, or mislabeled poisons. Ginger beer? Obviously not an inherently dangerous article.
Because of that, they feared that holding manufacturers liable for everyday items without a direct contract would simply make it impossible to carry on trade. To them, the risk to business was just way too high. Moving on to Section 4, the neighbor principle. This is where a brand new legal duty gets born. The progressive judges pushed back on that business argument hard. Judges like Lord Atkin and Lord Macmillan argued that the common law isn't just some static thing. It absolutely must adapt to the modern reality of mass-produced goods, especially when manufacturers are intentionally shipping products all over the country. Lord Atkin delivered this powerful, enduring rebuttal. He stated, "I do not think so ill of our jurisprudence as to suppose that its principles are so remote from the ordinary needs of civilized society as to deny a legal remedy where there is so obviously a social wrong." He was basically saying the law simply cannot turn a blind eye when a consumer is poisoned by a manufacturer's carelessness just because of some archaic technicality about contracts. So to bridge this gap, Lord Atkin formulated this incredibly famous concept known as the neighbor principle. It states you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. He essentially took a moral rule and translated it into a strict legal duty, which permanently altered the relationship between corporations and everyday consumers. But, of course, being a brilliant lawyer, Lord Atkin knew he had to define the limits of this. He couldn't just leave it open-ended. So he asks this fundamental question in his judgment. Who then, in law, is my neighbor? It's a profound question, and really it's one you should ask yourself about anyone your own actions might affect. You can't be legally responsible for everyone in the whole world, so where exactly does the law draw the line? The answer he gave was a real game changer. He said, your legal neighbors are persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation. In the context of our explainer today, Lord Atkin declared that a manufacturer putting up an article of food in a container absolutely must contemplate the ultimate consumer. They know for a fact the consumer will be directly affected if they negligently allow the contents to be mixed with poison. Section 5, a new legal world. Let's look at exactly how they applied this principle. So, how did all this high-level legal theory apply to the actual snail in our ginger beer bottle? Lord Macmillan, another judge in the majority, pointed out some crucial physical details from the source material. First, the ginger beer was in dark, opaque glass. Second, the container was sealed tight with a metal cap. Because of this setup, absolutely no intermediate inspection by the retailer or by Mrs. Donoghue before drinking it was even possible. And this wasn't an accident. The manufacturer intentionally prepared the product to reach the consumer in the exact condition it left the factory. They actively excluded any outside inspection. So the absolute crucial takeaway here is this. By sealing that opaque bottle, the manufacturer assumed a direct legal relationship with the consumer, completely bypassing the retailer entirely. Because you couldn't see the snail, and because the bottle was sealed so tight, the manufacturer remained legally responsible right up until the exact moment that bottle was popped open and poured over the ice cream. Control of the product effectively remained with the manufacturer until it reached the consumer's hands. And just like that, the old requirement for a direct contract was completely shattered. In the end, the House of Lords ruled in favor of Mrs. Donoghue by a 3-2 majority. We're going to leave you with this really empowering final thought from Lord Macmillan. The categories of negligence are never closed. As society evolves and mass manufacturing continues to grow, the law adapts with it. So the next time you open a sealed, mass-produced item, maybe ask yourself, exactly how far does the manufacturer's duty to you really stretch? Thanks for joining us for this explainer.